immunities arising from Cap 12 of the laws of Zambia. This immunity is against any prosecution, that you cannot be prosecuted in any court of law for the interaction you are making today, neither the submission that you are going to present be used in any court of law in Zambia. However, the same Cap 12 can be used against you if it is found that you deliberately misled this committee during its interaction with you. But the idea is not to prosecute anybody, but to level the ground, to give freedom of expression, and help the committee drive to a reputable report, and therefore you should feel free and fair when you are interacting with this committee. At this juncture, I would like to state that we are in receipt of a submission from JCTR, and I would request the leader of that delegation to present the submission in a summarized manner, because I'm looking at the bulkiness of the document. So after that presentation, we shall wait for some observations. So I'm calling upon the leader to present the submission.
So, Chair, thank you very, very much for your hospitality. Chair, on the 4th of October last year, this esteemed committee requested JCTR to submit a memorandum concerning the plight of circumstantial children. In your request, you asked for a detailed memo highlighting the following aspects of this population group: the adequacy of the legal framework governing their support, their number in Zambia, the measures that the government has put in place to enhance for the care of circumstantial children, and the challenges which may be faced by them in their care. So, having submitted our research and made our recommendations with regards to the provision of support for circumstantial children, we would like to give a brief summary of what our research uncovered. So, Chair, before outlining the situation of this population group in Zambia, we would like to provide this esteemed committee with a description of the perspective that JCTR brings. I don't know, all of you have heard of JCTR? Do you know JCTR well? If you know us well, you know that we are a faith-based organization formed by the Society of Jesus in 1988. So we've been around for a while. And it is our concern to translate Christian principles into action while working to promote justice in Zambia. So it is this faith perspective that we bring to this material today. We believe firmly in the God-given and inherent dignity of every human being, which dignity is protected by human rights instruments internationally as well as the fundamental laws of Zambia. It is from this perspective that we are presenting our findings today. So let us be clear from the start. The situation facing circumstantial children is far from ideal, and we would like to make a plea to this esteemed committee to do everything in your power to help them and to assist the Zambia Correctional Service to better serve the mothers who bear the burden of supporting children while in prison. So, Chair, having started with this plea, allow us to reflect on the challenges facing circumstantial children in Zambia. First of all, the term circumstantial child was coined in 2004 by an official of the Prisons Department in Zambia, referring to a child who was either born in prison or who came into prison with their mother when their mother was convicted. The first challenge facing these children is that they are not strictly prisoners, but only join their mothers in prison up to a certain age. The thinking behind this is surely that it is better for the growth and development of the child to be with their mother for as long as they can be at the start of their lives. So the assumption is therefore that life in a prison environment is better for the child as opposed to a life outside the prison and to be separated from the child. So the question is that assumption correct? Chair, this assumption would only be correct if these children got the support necessary in correctional facilities for their growth and development. It is JCTR's contention that this means the child should be provided with adequate food, clothing, accommodation, education, and leisure, which is appropriate for children of their age. The big question is, are circumstantial children getting all of these things? Chair, our research from reports released in 2013 and 14 and 17 show that there is an inadequate supply of food and clothing to this population group. The 2017 report indicates that incarcerated mothers are giving their own food provisions to their children, depleting the food which is there for their own support, and giving adult food to young children, which is not ideal for their development. Furthermore, the 2014 report indicates that there was no budget for circumstantial children in the prison system. And I think my colleague has confirmed this morning, you're looking at the Yellow Book for the 2023 budget. There is no such budget specifically outlined for circumstantial children in the present budget. So, Chair, concerning accommodation, adults and children are meant to be kept separately, according to the Zambia Correctional Services Act, and men and women should be confined separately. The ideal is also that mothers and circumstantial children should be confined in their own accommodation for the best interests of the children involved. However, this is not being done. The 2014 report we looked at suggested that mothers in some prison accommodations are sleeping in cramped quarters, with children sleeping on their chests. Even in Kamfisa female prison in Kitwe, with separate accommodation for mothers, some mothers had to sleep near bathroom and toilet facilities, which is not good for a child's health and well-being. From the 2017 report in Lusaka province, the Human Rights Commission discovered that mothers with children as young as 2 days old were found in prison cells with other inmates. This represents a situation where young children and adults are confined together, which is not good for the safety, security, and development of the child. Chair, seeing that education is one of the necessities to be provided to a child, as recognized by the Convention on the Rights of the Child, as well as by the free education policy of Zambia's government, we can ask whether circumstantial children are getting the education that they require. According to the 2014 report we consulted at the Kamfisa female prison, there was no classroom for children and there were no teachers. The same situation was identified by two other reports 3 and 4 years later, in 2017 and 2018. Schools and playgrounds for children would be ideal, but prisons are simply not adequately built for these facilities. This means that off-site visits to these facilities to provide these, the leisure and education have to be organized, and this option is not being exercised nearly enough to benefit circumstantial children. Chair, these are the challenges being faced by circumstantial children, and JCTR would like now to make certain recommendations that can be found in our memorandum to ameliorate the situation that they are facing. Namely, amendments to the recently enacted Zambia Correctional Service Act, the Penal Code Act, as well as proposing a better provision in the budget for circumstantial children. Moving on to the first recommendation, Chair, how might the Zambia Correctional Service Act be amended? We are suggesting 3 main amendments. The first is to broaden the definition of clothing and necessaries mentioned in Section 30 of the Zambia Correctional Service Act. So according to this section, the state in Zambia is obliged to provide circumstantial children with clothing and necessaries when admitted at the public expense. But what does the term necessaries mean? It could cover anything or nothing, depending on the interpretation given to the reader of the statute. JCTR would like to recommend extending this description to include more specific items. So as our research indicates, the Correctional Service Act of 1998 in South Africa expresses it in this way. The Department of Correctional Services is responsible for providing food, clothing, healthcare, and facilities for the sound development of the child for the period that such a child remains in prison. This wording is broader than the Zambian equivalent, although JCTR would recommend including other essential items as well in this list, such as educational and leisure facilities for children. This would make this provision more specific and would help extend more specific care to this population group. Chair, the second amendment to the Zambian Correctional Services Act would be to make the foundation of the decision to discharge a circumstantial child from prison made by the officer in charge to be in the best interests of the child. Currently, Section 30 of the Zambia Correctional Service Act simply states that the officer in charge has no discretion about discharging the child. All the Act requires is that the child should be weaned and is able to be supported either by a friend or relative of the inmate or by the Commissioner of Social Welfare. However, Article 3 of the International Convention on the Rights of the Child says that in all actions concerning children, the best interests of the child should be the primary concern. Section 30 of the Zambia Correctional Services Act should therefore be amended to reflect this concern. We list in our memorandum an example of Section 20 of the South African Correctional Service Act, where it says that a child should accompany a female inmate into prison until the child is 2 years old or until such time that the child can be appropriately placed, taking into consideration the best interests of the child. This means that the officer in charge has a